Hello, K-Squid listeners. It's every other Sunday again, and you're listening to Sustainability Now, a biweekly K-Squid radio show focused on environment, sustainability, and social justice in the Monterey Bay region, California, and the world. I'm your host, Ronnie Lipschitz. What do you know about CEQA, the California Environmental Quality Act, passed in 1970 and signed into law by then Governor Ronald Reagan? For more than 50 years, CEQA has been used to inform decision makers and the public about the potential environmental impacts of proposed projects. But in recent years, it has been applied to situations for which it was not designed, especially new housing development. In response, both Governor Newsom and the state legislature are seeking to amend the law to prevent various activists and opponents from obstructing new housing. Not so fast, say the law supporters. They point to a recent report by the Rose Foundation that CEQA has had little, if any, impact on housing projects across the state. So, who is correct? My guest today to talk about CEQA is Professor Deborah Sivas, who is the Luke W. Cole Professor of Environmental Law at the Stanford Law School, where she's also director of the Environmental Law Clinic and the Environmental and Natural Resources Law and Policy Program. Her current research is focused on the interaction of law and science in the arena of climate change and coastal marine policy, and the ability of the public to hold policymakers accountable. Professor Deborah Sivas, welcome to Sustainability Now.
Thank you. Glad to be here.
Why don't we start at the beginning? What do you do at Stanford precisely, and how did you end up there?
Yeah, so I am officially a professor of environmental law at Stanford Law School, and I also have an appointment in the new School of Sustainability. But I've pretty much worked my entire legal career in the environmental field, and actually started out as a biology major and then was in graduate school in ecology and kind of switched over to the social science side and went to law school, but knew I wanted to work on environmental issues and have done that pretty much my entire career.
And was there anything in particular that led you into environmental law?
It was a really different landscape when I was when I was young, and I grew up in Southern California, and I always say that if you grow up down there, you're either completely oblivious to environmental issues or keenly aware of them. And so I grew up in the 60s and 70s, and smog was a huge issue. We had, pesticides were an issue, coastal development. So I guess I ended up on that side of the line, and that really compelled me. I mean, we're in a really different world now, but I'm glad that across the spectrum, more people are tuned in to environmental issues.
Okay. And what does the Environmental Law Clinic do?
So a law clinic is an opportunity for law students to actually get some practical experience. So when I went to law school, where there were no clinics, and so you just took classes, regular substantive classes, and then you got out and you didn't know how to do anything. You didn't know anything about practicing law. So these days we have a pretty robust clinical program here at Stanford, as do many law schools, and students get to plug into the clinic. They take the clinic as a class. What's really unique about our program is that when students are in clinic, they're full-time. They don't take any other classes. They just work in the clinic full-time. And they get to represent real clients. Our particular clinic represents mostly NGOs, non-governmental organizations, in environmental and energy issues. And so students get to work on those cases. They interact with the clients, they write briefs, they go to court and argue, write petitions, all that thing. So the kind of skills that you need as a practicing lawyer.
I mean, they actually can go and do pleas in court, even though they're not licensed.
Yeah, so they get certified through the State Bar Association, and we of course oversee their work. I have a staff of there's about 5 of us lawyers, licensed lawyers. And the students practice under us, very, very circumscribed, but they get to go argue in court, work on briefs, interact with the clients, so they get to develop those real skills.
Well, we're here to talk about CEQA, so why don't we get to that? What exactly is CEQA, and what is its mandate? Give us some history of it as well.
Yeah, for sure. So California Environmental Quality Act, CEQA, modeled after some people have maybe heard of NEPA, which is the federal statute, National Environmental Policy Act. And California adopted a very similar law in 1970, following on the federal law. And the whole idea behind the law is to make decision makers at every level of government, so, local government officials, any kind of regional organizations, all the way up to the state agencies, to really think about the impact of any proposals that they might approve, and really consider those impacts, and then think about whether there are ways that are less environmentally destructive to approving those projects. So it's largely a disclosure law. So it allows the public to make comments, and it requires the agencies to disclose impacts, but it also is meant to make the agencies stop and think before they just approve projects, and really think about the consequences. And in the early days, it was important around kind of traditional things like air pollution and water pollution, pesticides, all of that. And that's important today, continues to be important. But of course, now we've also got climate impacts and how projects might affect that. So remains very important today.
Well, I was doing some reading about CEQA, and I came upon the California Attorney General's website, which said, quote, CEQA requires that state and local agencies disclose and evaluate the significant environmental impacts of proposed projects and adopt all feasible mitigation measures to reduce or eliminate those impacts. Now, please correct me if I'm wrong, but I've long been under the impression that the purpose of environmental impact statements is to acknowledge that these environmental impacts might take place, right? And the developer or the agency can decide what to do, but they're not required. My sense was they're not required to actually do mitigation. Am I wrong?
Yeah, actually, in California, it's a little different than the national law, NEPA. And let me just step back on that one. So at the federal level, for federal agency actions, NEPA is the statute that applies, and it's a similar statute that requires agencies to really look at the environmental impacts of projects that they might approve or that they might carry out themselves. But the courts have long interpreted NEPA from very early days to be completely procedural. That is, you can, as long as you adequately disclose the impacts, the agency can make any decision it wants, and it doesn't have to modify the project in any way. So that's entirely procedural statute. The one modification when California adopted that model was to say that it was to require agencies to look at potential mitigation for project impacts, and in fact to adopt mitigation where that mitigation was feasible to adopt and could lessen the environmental impacts. Now, it's not a hard and fast rule, because there is a way for an agency to escape that path by doing something called a statement of overriding consideration. So we admit that there's significant impacts from this project, but we think there are other reasons to override that concern and actually go forward with the projects. But short of that kind of a statement, the agencies are supposed to mitigate to the extent feasible and possible to do. So there's a little bit of substantive content that the federal law does not have, but the state law has.
Okay. I want to ask a question about that. So if what I've seen is that private developers are now are making or required to make these environmental impact studies, right? And are they subject to that requirement?
Yeah. So the way it works is that CEQA is only triggered where where an agency, a local, regional, or state agency, has to issue a discretionary decision to approve a project. So, for instance,
Okay.
if you're an individual landowner and you want to build a new house, right? And all you need to do is go get building permits, and those building permits don't really involve any discretion. You meet the standards, the building code standards. You don't, CEQA does not apply there because there's no discretionary approval. But once there is some kind of discretionary approval, whether it's a local permit or an air permit or a water permit, Endangered Species Act permit, whatever approval from a government agency, that potentially triggers CEQA there. And we can talk about the different categories of CEQA that apply. So that's how private parties get pulled in. And if there is a discretionary approval, then the agency does have to look at mitigation and would have to condition the project on that mitigation unless it finds that it's not feasible to do.
Mm. Well, and I also read that the CEQA is a self-executing statute, which of course sounds puzzling uh, since it has no agency of its own. But what does that mean exactly?
Yeah, I think that just means that every agency has to comply. So yes, unlike, the California Air Resources Board, which oversees air quality, right? The CEQA applies across the board, as I said, to every agency that would be making some discretionary decisions. So in that sense, every agency has to make sure that it's complying with the law, and the law applies whether or not you've actually got citizens out there who are concerned about it. It just applies in every instance. And as you probably know, there is citizen enforcement, which I will talk about, I'm sure. But even without citizen enforcement, every agency is supposed to make a determination at the beginning of the approval process whether CEQA is triggered, and if so, what level of review it needs to conduct.
You're listening to Sustainability Now. I'm Ronnie Lipschitz, and my guest today is Professor Deborah Sivas of the Stanford Law School, who works on environmental law and various related topics, and is also director of the Environmental Law Clinic at Stanford. And we're talking about CEQA, the California Environmental Quality Act, which was passed in 1970 and then signed into law by Ronald Reagan. Those were the days, weren't they?
Absolutely.
So you mentioned something about citizen. What was the term?
Citizen enforcement. Right.
Enforcement. So, okay, how does that work? What does that mean then?
So one of the things about CEQA is it's a very transparent and kind of public-oriented statute. So disclosure to the public, and there are processes that go along with that, depending on the level of review that's necessary. But where the public can weigh in during the agency's consideration, if they're going through the CEQA process, there's usually an ability for the public to comment. And then once the agency has made a decision and issued the approval, any member of the public that has participated in the process, the review process, by doing comments or showing up at a public hearing, that kind of thing, could then bring a judicial challenge that says, agency, you did not do enough to comply with the requirements of CEQA. So that's what you hear about a lot in the news, is these CEQA lawsuits. They're generally brought they can be brought by communities, citizens in the community, NGOs. Actually, private business actually brings a lot of those lawsuits too. You don't hear too much about that. But and then the court will look at what the agency did and determine whether it was adequate to comply with full disclosure under CEQA.
Well, and now, so does that mean that, let's say plaintiffs bring a case, right? They file a lawsuit and the courts file in their favor. Is then mitigation required? Right. I mean, they find that indeed there was a failure to take into consideration a particular, environmental aspect that has to be addressed. Does that mean then that the agency or developer does have to apply mitigation?
Yes. So if a court finds that, so there's a couple of things that a court might find. One is that the review they just didn't do the right level of review, and we
Hmm.
could talk about that. There's kind of these more abbreviated reviews. In California, the term is negative declarations. Or do they have to do a full-blown environmental impact report, which is a bigger document? So sometimes there's a challenge that says, oh, you just did the abbreviated version, but this is a very significant impact that could have potentially big impact, consequences. And so you should have done a more robust EIR, environmental impact report. So sometimes that's a challenge. Sometimes the challenge is, well, you did an EIR, but you did not adequately consider traffic um, concerns or air pollution impacts or whatever it is, and the courts will look at that and decide, was enough done or not. Um, so that's another kind of challenge. And then a third kind of challenge is that you didn't adopt the mitigation and you didn't show that it wasn't feasible to do mitigation, or that there were overriding considerations here, and so you need to actually adopt the mitigation and make it as a condition of the project. So those are all different ways that citizens might, or anyone might, challenge the adequacy of what the agency did in terms of complying with CEQA.
Who enforces that decision or that, command?
Well, that's a good question. So the way these suits work is whoever is challenging, called the petitioner, will
Right.
file the suit in court, and the agency is actually the defendant. So if there's a agency that's issuing a permit, the the private entity that's receiving the permit is called a real party in interest. So they're part of the case, but they're not actually the respondent or the defendant in the case. It's actually the
Uh-huh.
agency defending their own action, right? So
Uh-huh.
you're suing against the agency. So if you win a suit, a court will then issue what's called a writ of mandate and order the agency to go back and do more review or do more mitigation analysis or whatever it is that you win the lawsuit on. And then the agency has to report back to the courts at some point that the court sets, to say, here, okay, we've done what the additional analysis, and here we're presenting it to the court to, pass muster, and we want to be now freed from any more responsibility. And then the court will look at that and decide whether they've done enough or not to comply. So there is a mechanism for actually following through on a court order, which is interestingly indifferent than the federal. If you win a case on NEPA in the federal courts, that's it, and you hope that the agencies go back and do it. If not, you might have to sue them again, but your court case is done. In California, the courts retain some jurisdiction to make sure the agencies are then doing the proper analysis.
Huh. Okay. You mentioned a negative declaration, and you said there were several categories of of
Yeah, so
EIRs, basically, or what?
yes, there actually are a number of different types of EIRs, but starting from kind of the least to the most onerous, I guess, if you want to think about it that way, is so first of all, there has to be a discretionary action. So if there's not actually a discretionary action, so sometimes agencies will say this is ministerial, it's a building permit or something,
Hmm.
and we don't need to do any CEQA. So that's the least. And then built into CEQA, there are a number of exemptions. And in fact, the legislature and the governor have increased those exemptions in recent years to cover more affordable housing, infill development, and a number of other things. And so that if an agency determines that it falls within one of those exemptions, it actually doesn't have to do any more review at all. And then the next level is a negative declaration, where the agency looks at the um, what impacts the project will have and says they're not going to be significant. So we're just going to go through the checklist. What are the air impacts, water impacts, greenhouse gases, etc. And we're going to find that none of them are significant, so we don't have to do any further analysis. So that would be a negative declaration. Then there's something called a mitigated negative declaration, which says, okay, we've looked and maybe there's one category of impacts that could be significant, but we're going to mitigate those to a level of insignificance, and then we're going to issue a mitigated negative declaration. And that's the end of what we have to do. So those are all the kind of more abbreviated fashions. If there's impacts that don't appear to be able to be mitigated as part of the project itself, then the agency has to go through a full-blown environmental impact report. Still needs to mitigate once it does that full report, but that's the thing that I think you hear complaints about, that takes, it can take up to a couple of years. And then, so that's a full-blown EIR for a project. And then uh, there are ways to, if there's been like a general plan, so there's a big EIR done with a general plan that designates land uses in a city or a county. And sometimes you can what's called tiering off of that and do a more abbreviated EIR because you've already covered most of the impacts with the general plan and you're just looking at the specifics of the project. So there are those kinds of EIRs too that can be a little more truncated. So there's a whole range, a whole spectrum of ways to comply. And those are often the most contentious. Did the agency do enough? Should it have done more?
I want to bring up a local case. The UC campuses are required to do long-range development plans, right, every 10 or 15 years. And then I guess they have to do an EIR on the development plan. And one of the interesting phenomena or features of that is that these long-range development plans rarely get completely fulfilled. So when there are lawsuits filed against them, they're being filed against a substantial number of elements of the plan that will never come to fruition.
Mm-hmm.
And I mean, it's kind of, you're filing suit against what is someone's imaginary version of what the future looks like. I don't think that happens. That may happen in other general planning. I don't know. The Solano County case where the investors are promising to build 3 model cities, right?
Right.
And I suspect that's not going to happen, but there are liable to be all kinds of lawsuits against these visions.
Yeah.
Go on,
So,
sorry.
oh, I was just a couple of points about that. I think that is right because if you have an EIR, a big EIR that's done on something like a general plan, right, sprawling. But the reason that sometimes those EIRs are challenged is that those general plans say, okay, here we're going to put this kind of activity in this zone and this activity over here, and this is what the criteria are going to be for development. And so one of the things about CEQA is it has a very short statute of limitations, which means the time in which you can legally challenge it, right? So it's very different than the federal law, which is could be many years later you could challenge an action. In CEQA, the idea is you have to challenge it within 30 days. So that's a pretty quick,
Wow. Yeah.
agency makes a decision, it's had a process, it's produced some kind of document, neg deck, EIR, something. And within 30 days, a petitioner has to challenge or lose their ability to challenge. So with a general plan, you have to make a decision, is there something here that really locks in development rights that we would not be able to challenge later? And I think that's the decision that petitioners counsel often make is, or should we wait for the specific project that comes along,
Okay.
right? But yeah.
I see. I understand. You're listening to Sustainability Now. I'm Ronnie Lipschitz, and my guest today is Dr. Deborah Sivas from Stanford Law School. We're talking about CEQA, the California Environmental Quality Act. I have been reading a lot, and I have been hearing a lot about CEQA being an obstruction to new housing, affordable housing, and all kinds of housing. What is that all about?
Yeah, well, so there is as you point out, there's a kind of robust debate that's happening right now. We all know that we have a housing crisis in California. I don't think anyone credibly would deny that. The question is CEQA the source or an important source of the problem? And there are a number of analyses and studies out there that have tried to get at this issue. And the question is the availability, so the requirement that agency, mostly local government agencies, have to go through the CEQA process, is that somehow, and then the ability of citizens to challenge those approvals under CEQA, is that somehow inhibiting the development of new housing that we need? That is the core debate, and there's very strong opinions all around, and quite different opinions depending on who you're talking to.
So the conflict involves a rather strange cast of characters, in the sense that you've got NIMBYs, right? Not in my backyard, along with cities and some environmental organizations. And then you've got YIMBYs, which is yes in my backyard, right? Which also includes cities, residents, developers, conservatives, and some social justice groups. So maybe you can expand a little bit on what the conflict is about. And I'm wondering, why does CEQA apply to something like why would CEQA apply to something like a housing development? Maybe that's the first question to ask, and then go to the cast of characters.
Yeah, that's a great question. So again, I think I used in the beginning, if you're just an individual landowner and you're building your single family house or your duplex or whatever on the property, CEQA probably does not apply. In uniformly, local governments, there are building code standards. As long as you meet them, setbacks from the property and square footage and all of that, and all the rules about the building codes, you meet that, you're not really getting a discretionary approval. You're just getting sign-offs by the building department, and CEQA would not apply. When CEQA starts to apply is larger projects, so those tend to be more the multi-family housing units, in addition to just industrial and commercial developments, where those projects, often cities have criteria, but they have a process called the conditional use permit or something similar, where as a developer you have to go in. Usually if it's a bigger project, there's a lot of working with the planning department in a city or county ahead of time to try to work out all the parameters of that, and those are usually subject to conditional use permits. So that's a discretionary action that the local government has to approve, and that's the point at which CEQA gets triggered. That's why CEQA gets triggered with these larger development projects. But it kind of depends on what is in the local code and what is required, what's allowed under the building code, and what requires that additional layer of discretionary approval.
Can you talk a bit about the parties, these two groups?
So as you can imagine, developers have long disliked CEQA, not just in the current housing crisis, but I would say I've been doing this for a while, way back to the early days of CEQA, because of course it's just another regulatory hoop they have to go through, right?
Mm-hmm.
And opens their project to public scrutiny and potential challenge. I mean, of course, the point, when you think about it from a democracy standpoint, is that the public should have a say in how their communities are developing, and there shouldn't be sweetheart deals with cities and counties, which I think prior to CEQA there were a lot of deals like that on the coastal side as well, and that's what resulted in the California Coastal Act, was to try to give the public more of a say. So developers have long not liked it, but in recent years, I would say in the last decade, the developers have started to take up this idea that CEQA is really the reason that you're not getting more housing developed in California, and they have built an alliance with the YIMBYs, as you say, yes in my backyard folks, which are, they tend to be, it's interesting, right? Because they tend to be a lot of younger, progressive activists who want to see more housing, which I think we all do, and they've kind of taken up this mantle that CEQA's part of the problem, or potentially a large part of the problem. I have a view on that, having litigated in the trenches and also read all of the studies, that CEQA is a very small part of that, and that there are lots of other things that are playing into the housing, our failure to develop enough housing. But CEQA has become the kind of the thing to blame, but that and what it is allowing the developers to do is to get a lot of legislative exemptions um, I think it remains to be seen whether any of these exemptions are actually doing anything for
Hmm.
getting us more housing, particularly affordable housing. I think the fact is that the affordable housing exemption, the infill exemption, those exemptions that have been built into CEQA in the last few years in response to this concern have not, the studies so far don't show that they're leading to any more housing. So I think the concern is by some on the more, environmental side is that this is just the industry using the housing issue as a way to kind of really gut the statute, and which is something they wanted probably all along.
Hmm. Um, and you mentioned has CEQA actually blocked new housing? I mean, there've been, and it's these few cases that make the headlines, of
Mm.
course, make it seem like it's going on everywhere. But from what I read, there are very few instances in which CEQA has been invoked in the case of housing.
Yeah, no, I think that's absolutely right, and that's what some of these more independent studies are, I think, showing. I don't know the current statistics, but it's just a few percent, 2 or 3%. First of all CEQA potential matters are
Hmm.
litigated, right? So you
Hmm.
start with that it's a very small percentage of. So if you think about it, local governments make decisions all the time, state agencies too, and regional agencies, but particularly local governments are making decisions all the time, right? Every single one of those is potentially subject to CEQA. Might be the city or county might find it to be exempted or a neg deck or whatever, and sometimes a full-blown EIR, but those are happening all the time, and only a couple of percentage of those are ever even challenged in court. And then I think what the studies have shown is that um, not very many of the projects that are challenged are actually housing related projects. I think
Hmm.
so. The most recent things, there's a group called CEQA Works which has done a couple of studies, and I think their most recent study, which just came out a few months ago, showed that just under a quarter of all CEQA lawsuits, again, that it's not that many lawsuits, a couple hundred a year out of the thousands and thousands and thousands of decisions that are made every year by agencies. But even of that small set of challenges, I think it's slightly under a quarter of them relate to something that has a housing component. Could be a whole housing development, but it could also be housing as part of a larger commercial development.
Hmm.
So, um, so when you think about those numbers, it's not a very big percentage out there, and the vast majority of housing projects go forward without. They may be stopped for other reasons, but they go forward without a CEQA challenge to them.
Well, the barrier to litigation by the public is pretty high since it costs so much to bring a case to court. Someone has to have deep pockets, right, to be able to do it.
Yeah, no, that's true. So it could be. So I think one of uh the one of the arguments is made is like, oh well, wealthy communities, people can afford it because, right, the those communities could afford to hire lawyers, and that could be true, and I can't refute specific instances. I'm sure that some of that goes on, but the vast majority of CEQA cases are actually brought by community-based groups. They don't have the resources largely to hire lawyers. And so the lawyers who take on those cases are usually doing them on a contingency basis. So they would only get paid if they win the case. So you can imagine the incentive. There's a lot of,
Mm.
smaller firms and private practitioners. As a clinic, we do some of it for pro bono for our clients. Uh, but for most of the attorneys out there, they have to feel pretty confident they're going to win the case, that they have a good set of legal arguments before they would take on a case for which they're not being paid and would only get paid at the end of the day. So that, yeah, and I talk to groups all the time because we provide pro bono work that our students do, and so we get, of course, lots of calls, and we turn away most of them. And so most of those community groups don't have the resources to hire a lawyer. So it isn't like, again, it's not to say there aren't some wealthy people who might not want the housing development next door. Maybe they're funding some of this in, Atherton's and the Los Altos and Palo Altos of the world, but that's largely not what's going on with CEQA.
Yeah, arguably, if it were easier to litigate, there probably would be more cases, right? More
Yeah,
cases
that's
filed.
that's right.
I mean, we were talking about, I think, democracy of some sort, or public involvement came up, right? And it's limited to making comments during the comment period, which tend to be ignored. Well, because of all of this hoopla, and I don't know, I know it's been in the Chronicle, the San Francisco Chronicle, a lot. I don't know about the other big newspapers, um, and I don't know what's going on online. The governor and legislature have made noises about streamlining CEQA in order to remove this obstacle, so-called obstacle to housing development. What is that all about?
Yeah. Well, it is part of this larger, I think, strategy by those who don't like CEQA. And I definitely think they have the governor's ear and the ear of many legislators. And uh, it's interesting at the federal level where everyone is paralyzed, right? And none of the old laws like NEPA have been touched for decades now. CEQA is really different. The California legislature operates in a different way and is actually quite responsive to, whatever the moment is. And so over the years, there's been a whole slew of uh, carve outs and exemptions built into CEQA. I don't know if you remember, but a few years back it was about sports stadiums because somehow those were so important to have that we had to like carve them out and not require CEQA for those. So what was that about? It was, wealthy sports teams owners getting a legislative exemption. But in the more recent years, there's been a series of small carve outs and exemptions. I think I mentioned a couple earlier. It's for affordable housing. If you have a certain level of affordable housing in your project, or for infill development close into public transportation and those kind of things, which we want to encourage for density purposes. So there's been these small carve outs. And as I said, I don't think that they're being really used because that's actually not what developers want to do. Most
Right.
developers don't want to develop low income housing near transit stations. They want to build high income, uh,
Condos.
condos, yeah, in Palo Alto or
Yeah,
whatever. So,
yeah.
um, so they throw in because they've got requirements to do some percentage of affordable housing. They'll throw some of that in, but those exemptions have not really. It has to be a substantially affordable income project. So they haven't really been used. And now, but with these one law firm in particular that's generated, I think, 3 reports now. They represent the heavily developer financed law firm, and they've generated a bunch of studies that I think the legislature has looked at those and said, well, we should do more streamlining, so even more than we've done so far. And so there's been a number of bills to continue to expand these carve outs. And that's a continuing fight. The governor has signed a few this year, but there are more potentially coming with bigger carve outs. So I think there is a worry about people who think of CEQA as our main public tool for keeping local governments accountable, are worried that there's going to be this wave that washes through and really guts the statute. I don't think we're there yet with any of the legislation that's been proposed, but it's 1,000 cuts happening right now.
Yeah. What has Newsom said he wants to do? I looked into it and I found it a bit confusing. What's being done, or what's been proposed?
Yeah,
What
so
exactly?
well, right. So Newsom he has to continue to express concern that Seek was the problem. And I think we could maybe talk about what other sources of the problem are. But
Yeah.
and so he's been willing to entertain bills coming across his desk. And so there's a new one. There's one right now. I'm trying to remember the number, AB 1633, I think. And it again waters down the standards, and it makes it easier for developers to get projects through without much secret review. And it's actually
Hmm.
coupled with everyone's talking now about the builder's remedy. So the Affordable Housing Act, which passed a few years ago, right, as part of that, they're now trying to tether some CEQA exemptions to that law, and that hasn't gone into effect, but it's floating somewhere in the legislature. I don't do a lot of legislative work, so I'm not sure where it is in the
Yeah,
committee.
yeah,
But yeah, so each one is sort of a broader carve out than the last. And I think the legislature, the way it's justifying that is, well, we did this a couple years ago. We're not getting any more housing, so let's do some more carve outs, right, and make it easier um, on developers and try to push the cities to get the sequel. And part of it is trying to reduce the delay. There is a delay. So a couple things. If a project is if the CEQA claims are not good claims, you're just not going to see that much litigation because people aren't getting paid to do those. I mean, like I said, occasionally, yes, but not really. So, the first question is, are we seeing a lot of CEQA lawsuits that are losers, and that would eventually be thrown out of court? So I say no. But even so, there is a written into the law itself that CEQA cases are supposed to be expedited. That's all to protect the developers.
hmm
And most counties of any size, I think if you're over a couple 100,000 residents, you're supposed to have a CEQA judge who has expertise in CEQA and who keeps cases moving through the system, right? So in fact, if they're not good CEQA claims, they'll get thrown out relatively soon, right?
hmm
And so um, you couple those things together, it just the worry that there's just delay going on, I think is not, again, could happen in individual cases, but generally across the board is not what's happening. But part of the legislation and the legislative reform is to, like, we got to keep streamlining, making it go faster, forcing the agencies to get these documents done more quickly or to invoke more exemptions and get them through the courts more quickly. So that's what most of the reform has been going to. I would say the developers would love to just get rid of the law altogether. Those who are champions of the law are fighting at the legislative level to keep those carve outs as narrow as possible.
hmm You're listening to Sustainability Now. I'm Ronnie Lipschitz, your host, and my guest today is Dr. Deborah Sivas of the Stanford Law School. We've been talking about CEQA and about the attempts, the efforts by developers, I guess, to get the legislature and the governor to somehow introduce carve-outs, which would exempt housing developments from the requirements of CEQA. Um, the poster child for all of this is the Berkeley case, right? Of the student housing in to the north to the south of the campus. Can you tell us that story? I don't know if everybody has heard it, and it's a thought-provoking one, I think.
Yeah. Well, yeah. So the idea in Berkeley is to, obviously there's a huge housing shortage in Berkeley with all those students, and that's probably true around all the big UC campuses. Um, and the idea was People's Park, which a little even predates me, and I've been around for a while, but was kind of a cultural icon in the 60s, uh, the 60s UC Berkeley movement. And but that park, my understanding, and I don't get to Berkeley all that often, but my understanding is that park has been, pretty much a haven for lots of
How do you put it? Yeah.
drug activity and other things in recent years. And so the university has proposed to develop it into student housing. Seems like a good thing. And some neighbors have then used CEQA to try to try to slow down that development. And one of the issues that they raised was that if you put student housing there, students are noisy, and that's going to have a noise impact on the neighborhood, which to me was a whole silly thing. And I actually didn't think that case was going to go very far when it was first signed, because, of course, considerations of noise impacts are important, but I think of it like they're building an airport next to the next to the neighborhood. There's a noise impact.
Mm-hmm.
Students,
Mm-hmm.
late night partying. But so it gets this, it got and a judge found it. And I won't because I don't know all the intricacies of the studies that were done, but it has now worked its way up to the California Supreme Court. That issue is now pending and is being briefed before the California Supreme Court. But it has become the poster child. And just about a week ago, I think Governor Newsom signed a bill that would exempt it from, and not just that project, but
But
housing projects around universities
around
from
universities, yeah.
CEQA. Yeah.
Yeah, yeah. What I thought was interesting about this is that CEQA says something about pollution, I guess, um, or it was used in cases of air pollution. So some bright bulb created the meme that people are pollution because they're the ones who are making the noise, and that's found to be an impact under CEQA, right? I thought that was
Yeah,
interesting.
people are pollution, right?
Interesting, right?
Yeah.
Yeah.
I mean,
Well,
it seems kind of silly, but it was holding up a project. But as I said, I feel like there's a few of these cases out there, and those are the
right,
things that the
right.
industry can glom onto and say, oh, now we've got to change the law, as opposed to kind of letting the process play out. And so, what you get in this case is a legislative reaction specifically to that one case. We're going to exempt University of California and Cal State, probably, I don't know if it covers community colleges, but housing around schools, right? But the the problem with that approach is that every time there's a poster child case, then there's a legislative reaction on that
Yeah,
point, right?
yeah,
And then pretty
yeah.
soon you've got all kinds of stuff littering the law with all these specific exemptions.
Yeah, well, I mean, there's no reason, in my view, to think that Berkeley will actually get around to building the housing after all of this time, right? It certainly is something that we see here in Santa Cruz at the university. You mentioned that there are other factors that are more important in obstructing housing development. Can you just mention those briefly?
Yeah. So, I mean, like, it is true. I think if anyone who's following the housing situation, that you see these more affluent communities who don't want a lot more housing, right?
Right.
And they're um, often their city councils are uh, denying approvals to projects or trying to make it more onerous in terms of the conditions they're putting on projects. But that is not CEQA happening. That is like local politics happening,
Yeah,
right?
yeah,
And
right.
um and so that's my frustration, is that we're blaming an environmental law that I know, as having used it a lot for environmental justice concerns, is about the only tool that environmental justice communities have to actually try to protect themselves. And I could talk to you all day about cases that we've done where that's exactly what we're doing, is trying to protect those communities. But in these affluent cities, and that's what's going on, is it's more politics than anything. I would say the one other thing, to the extent this is happening a lot in Southern California, which was developed later than a lot of Northern California, although I'm sure it's here too in parts of the Bay Area and parts of Santa Cruz, is that a lot of that subdivision housing that was developed in the 50s and 60s actually has um, deed restrictions written into those documents, which I did not even realize this until a few years ago, that say single family housing is all that can be built, right? And so a local government can't even really override that with higher density housing, because that's written into the deed on the land. So, those are really the things that we should be looking at, both the politics, but also, some of these other land use restrictions. And in my mind, rather than gutting a pretty useful environmental law uh, on the excuse that that's what's actually holding up housing.
Mhm, mhm. Well, we're running out of time, so I was wondering what do you think is likely to happen with and to CEQA in the future?
Yeah, well, I think it depends on who you talk to. So I have some colleagues who are very pessimistic. We're going to see CEQA, completely overridden. I'm not that pessimistic. I do think that some of these reforms will continue on for the next few years, but there is a vanguard of folks in Sacramento who do the lobbying stuff who are, pretty protective of the statute. So I don't think it's going to go away, and I do think, more analysis of how it's actually used to protect communities. And we actually saw it in connection with a proposed development in the old Cargill salt flats here off the peninsula, where at one point a couple years ago they were proposing to put 12,000 single family homes, and a lot of the out into the bay, right? And a lot of the groups were threatening CEQA challenges to that, and that backed that project off. It may come back, I guess. But that was exactly the opposite, because those groups were arguing we need high density housing on the land, not infill that puts a bunch of sprawling single family residents. So so hopefully it will stay around for those kind of situations, and the true environmental situations where pollution and air pollution, water pollution and things. But I do think there'll be more streamlining. Some of that will go on.
Well, is there anything you'd like to add, maybe that we didn't cover?
No, I think we pretty much covered the waterfront. I would just say that we probably need more. We probably need even more analyses of how CEQA, maybe how CEQA is actually effective at protecting communities, low-income communities, right? This is all about low-income housing. Well, I think low-income communities, the client groups I work with, they would be devastated to see CEQA gutted. So I think maybe more visibility of that issue.
All right. Well, Professor Deborah Sivas, thank you so much for being my guest on Sustainability Now.
Yeah, thank you for having me, and I'm glad you're working on this topic.
If you'd like to listen to previous shows, you can find them at ksqd.org/sustainability now and Spotify, Google Podcasts, and Pocket Casts, amongst other podcast sites. Thanks for listening, and thanks to all the staff and volunteers who make K-Squid your community radio station and keep it going. And so until next every other Sunday, Sustainability Now.